Hello and welcome to the LLG Grapevine podcast. You're listening to Helen Bennett, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG's Bulletin Editor. Hello, Dennis.
Hello, Helen.
Now, we took a break for a couple of weeks during Easter, but there's been no let-up on developments in local government law and practice. I say that every time because it's true. Now, the big news first. Paul Turner has been appointed as the new LLG president. So congratulations to him. And you can read more about Paul on our website in the news section. Now, news elsewhere, a man was jailed for defrauding Leeds City Council of over £700,000 in COVID-19 support grants intended for small businesses. So fraud in that area still being looked at. A former social housing tenant of L&Q was ordered to pay back over £95,000, including £75,000 under an unlawful profit order due to subletting their property 8 years. Subletting is still a very big problem in housing sector for local authorities and housing associations. And Fareham Borough Council successfully upheld an enforcement notice against a theatre company that built a 460-seat theatre without planning permission. And then, of course, we had the Supreme Court decision where the Supreme Court upheld the biological definition of a woman for the purposes of the Equality Act. And this ruling has sparked discussions about its implications for equality and inclusion policies. And Dennis, it's your first item of this podcast.
Indeed it is, Helen. The UK Supreme Court has ruled that the terms woman and sex in the Equality Act 2010 refer to a biological woman and to biological sex in a so-called victory for gender-critical campaigners. This case has been in all of the media, and much of the reporting focuses upon the euphoria from some quarters, which is not what leading Judge Lord Hodge quite had in mind.
No.
Quite rightly, Lord Hodge urged people not to see the decision as a triumph of one or more groups in our society at the expense of another. He said all transgender people had clear legal protections under the 2010 Act against discrimination and harassment. None of that has changed. So here we confine our comments to what the court actually decided by the judgment that it handed down. In 2004, the Gender Recognition Act of the British Parliament said that trans people should be treated according to their acquired gender for all purposes, and created the Gender Recognition Certificate as a way to affirm that protection. But the 2004 Act also said that this rule could be disapplied by specific reference in subsequent legislation, or if that legislation would be obviously unworkable. The Equality Act 2010 doesn't deal with that point explicitly. To reach a decision on this case, the Supreme Court therefore had to rule on whether, if applied to trans women with a gender recognition certificate, the protections against sex discrimination in the Equality Act would cease to function properly. And the court's unanimous decision was that they would.
Well, obviously, I've taken a look at the judgment. It's an 88-page judgment. And obviously, a lot of commentators have been scrutinising exactly what it said. But the judgment was explicit that interpreting sex as certified sex under the 2004 Act would cut across the definitions of man and woman, and thus the protected characteristic of sex. And the judgment further said that as a matter of ordinary language, the provisions of the Equality Act relating to sex discrimination against women, quote, can only be interpreted as referring to biological sex.
And the court also said that using the gender recognition certificate to define whether a trans woman should be granted the full protections of the Act was impractical, given that service providers are not even supposed to ask to see the certificate itself. And it's also said that from lesbian-only associations to changing rooms and single-sex halls of residence, a biological interpretation of sex is necessary in order to function coherently. Now, policymakers and decision-makers will now need to review their policies and guidance in light of the clarifications that this case has now provided. It is understood that updated guidance for public bodies is expected to be issued by the summer, But we will update on this in the vlog that accompanies this podcast, as there have been some recent developments. Lady Kishwa Faulkner, the chair of the Equality and Human Rights Commission, said, "We're going to have a new statutory code of practice by the end of the summer to reflect the clarifications provided by the Supreme Court decision." Helen.
Now, in other news, the Ministry of Housing, Communities and Local Government have issued a press release entitled "Planning Reforms to Slash a Year Off Infrastructure Delivery," with the news that clean energy projects, reservoirs, railway lines and other major infrastructure is to be built faster under changes to the Planning and Infrastructure Bill. Now, it's the government's position, and it states that, quote, "burdensome statutory consultation requirements unique to major infrastructure projects will be scrapped through amendments to the Pro-Growth Planning and Infrastructure Bill, cutting down the average 2-year statutory pre-consultation period by half and paving the way for new roads, railways and wind farms that will bolster the country's connectivity and energy security." And the government's views, and they're really determined on this, are that developers currently spend significant time and money on long technical documents, it says, resulting in communities feeling fatigued and confused, which they claim is a direct result of overly complex planning rules that are leaving working people deprived of the things their areas need to thrive. By they, I mean the government, states that it also disincentivizes developers making improvements to projects for fear of having to reconsult, even if it's in the community's best interest.
Now, Deputy Prime Minister Angela Rayner said, "Critical national infrastructure is key to Britain's future and security, so we can't afford to have projects held up by tiresome requirements and uncertainty caused by a system that is not working for communities or developers and holding back our true potential." She cited some examples of delays under the current system. Helen, these are quite interesting. I wasn't aware of these sorts of delays that are happening. The first example, the Fens Reservoir, over 1,000 days in pre-application due to a number of issues, including around consultation requirements, and the expected submission date will be in December 2026. And this project is for supplying 250,000 homes with water. Then she cites the National Grid project for Bramford and Twinstead, 717 days in pre-application for 29 kilometres of overhead lines and underground cables. And then there's Hinkley Point C, 3 years in pre-application consultation. Sizewell C spent around 7.5 years at this stage. Absolutely astonishing, Helen, when you see these examples.
Yeah, massive delays. But for balance, I think we need to look at the concerns around these proposals, and the Wildlife Trust in particular has raised concerns because they believe this is bad news for both nature recovery, communities and for infrastructure delivery. Now, they say that pre-application is intended to be the crucial stage when, informed by consultation with experts, potential problems with major infrastructure projects are revealed and solutions are found. And this is also the stage, the Wildlife Trust says, where nature protection and restoration can be built into the early stages of a project, which they say avoids harm to precious nature sites, protecting community green spaces and reducing costly project stopping trouble later on. Now, their head of public affairs is a guy called Matt Brown. And he's quoted as saying, "Only a month ago, ministers claimed that the bill would be a win-win for nature and development, and the government promised to protect nature. But this panicked misstep paves the way to a lose-lose-lose scenario for nature, communities, and infrastructure delivery." So there's a counter view to the government's proposals. Now, moving on, Dennis, you've been looking at a case related to Article 6 rights, I believe.
Indeed, I have, Helen. Now, here's the question. To what extent are parties entitled to support under the European Convention on Human Rights, and Article 6 in particular, in care proceedings? For those who appear in children cases, this raises some important questions and issues. The High Court has rejected a father's application for a lay advocate to support him after it was submitted that it was his Article 6 right to be provided with one in care proceedings relating to his child. In Walsall Metropolitan Borough Council and The Mother and Others, Mrs. Justice Leven said it would be useful to give judgment on the extent to which Article 6, the right to a fair trial, entitles parties to legal or lay advocate support in family court proceedings, following the submission made on behalf of the father in this particular case. The substantive application in the case centred on a care order for a 6-month-old, and the case was not contentious on the key issues involved. Counsel for the father submitted that it was the father's Article 6 right to have a lay advocate. Now, Mrs. Justice Leven said that this suggested such a fundamental misunderstanding of Article 6 that she decided it would be useful to give a judgment on the extent to which Article 6 entitles parties to legal or lay advocate support in family court proceedings.
Now, this is interesting and helpful, Dennis, because often the judiciary don't address matters to this extent where it's not crucial to the judgment. But I understand that the judge said it was clear from case law and the facts of the case that the father has no such right pursuant to Article 6 to a lay advocate.
Yes, indeed, Helen. Firstly, she said, there is no dispute because the father's position is not contentious. He is not seeking to assert any Article 8 right to family life or any other civil right because he is not disputing the making of the order or any of its provisions. Therefore, on the basis of the case law, as you say, Article 6, paragraph 1 simply does not apply. And Mrs. Justice Leven went on and said, having a lay advocate cannot in any rational sense be said to be indispensable for effective access to the court, given that he is not seeking to assert a case in court. Refusing the application, the judge said it did not mean the father was not entitled to appropriate assistance when the application was made, to ensure that he made his decision not to oppose the special guardianship order with proper advice, which he understood. And she added, it is essential that any such decision, which is potentially life-changing for the parent and the child, must be made on the basis of properly understood professional advice. But that is an entirely different issue from whether there is an entitlement under Article 6 to a lay advocate once that decision has been properly made. Helen.
Yeah, it's a helpful judgment, Dennis. Now, let's turn our attention to AI. Dennis and I found something interesting, didn't we, which we hadn't previously come across, which is the Artificial Intelligence Playbook for the UK government. Now, it's linked in the last edition of the Bulletin.
Indeed.
Now, this document, thanks for finding it, Dennis, actually. I should give you the credit for that one. It's a massive document. It updates and expands on the generative AI framework for Her Majesty's government and is intended to help government departments and public sector organisations, so councils need to be aware, to harness the power, it says, of a wider range of AI technologies safely, effectively and responsibly. Now, in January of this year, the government published the AI Opportunities Action Plan, laying out a bold roadmap for maximising AI's potential to drive growth and deliver real benefits to people across the UK.
Yes, and the AI Playbook is intended to support the public sector in better understanding what AI can and cannot do, and how to mitigate the risks it brings. It will also help ensure that AI technologies are deployed in responsible and beneficial ways, safeguarding the security, well-being and trust of the public that we serve. Now, this is a vast document, Helen, and it covers the principles that individuals should apply both before and during the use of AI. And these include understanding the limitations of AI, as we've pointed out before, and using it securely and having the skills and competencies to use it. And they also include data security, ethics, important to us, of course, legal compliance, governance, and legal considerations.
Yeah, it does, Dennis. And on the governance front, it states that in order to successfully develop an AI program, you'll need strong governance processes because of the risks related to unlawfulness, security, bias, and data. Whether these processes are already built into your existing governance frameworks or implemented as a new governance framework, it's going to have to happen. I think councils are really going to have to sit up and properly process this document and look to see how it can embed it throughout its organisation, because it's not going away, and it's only going to get more complex. So other matters includes within the document planning for the long-term sustainability of AI initiatives, considering scalability, long-term support, maintenance, ongoing stakeholder involvement, and of course, future developments. And as we know, technology advances with pace. So really, really helpful, interesting document, actually, I have to say, and one that local authorities may want to use as a basis for their own policies. Now, I do particularly like a bit of fundamental public law, Dennis, and you found a recent case on legitimate expectation, I believe.
Indeed, I have. But first, think of the word Grantchester, and it conjures up a 1950s rural village idyll with picture postcard scenes. And thinking further about the TV series, you might think of dishy young vicars swapping sleuthing for sermons. But now Grantchester is in the legal news, more accurately Grantchester Parish Council, in a case involving administrative law and, more precisely, as you say, the concept of legitimate expectation. On the facts, South Cambridgeshire District Council's leader did not give a binding promise at a local meeting that a new greenway would skirt the village of Grantchester, and the High Court found that, in any event, she would have no power to do so. Mrs. Justice Leven, at paragraph 46 of the judgment, states that the parameters of what statements can give rise to a legitimate expectation and in what circumstances are complex, with a large number of authorities on various but different factual situations. She observes that when considering these cases, it is important to have regard to the precise factual legal context in which many of the judicial pronouncements were made. At paragraph 47, she identifies three key stages in the legal thought process. Number one, was there a clear and unambiguous commitment? Number two, was it reasonable and legitimate for the promisee to rely upon it against the public authority? And number three, would it be inappropriate to allow the promisee to enforce the commitment? Now, at paragraph 49, she states that the burden of establishing a commitment which is clear, unambiguous, and devoid of relevant qualification rests upon the person asserting it. And at paragraph 50, that a distinction is drawn between what will be required in cases of substantive legitimate expectation rather than mere procedural expectation. And finally, at paragraph 56, the judge goes on to say that if the promise would interfere with the public authority's statutory duty, then it cannot give rise to a legitimate expectation. Helen, is that what you expected?
Well, it met my expectation, yes. And it makes perfect sense. I wonder how many people out there really understand whether a promise made would necessarily interfere with the public authority's statutory duty. You know, it's just a thought, but if you've got an official saying something,
my advice would be all councillors should be very careful what they say at all times.
Absolutely. Now, finally, for this edition, and taken from the LGA Bulletin, councils across England and Wales have lost almost a third of their staff over the past decade, according to new research by the GMB. I don't think this is going to be a shock to any of our members. The union said that 13 years ago, local authorities employed 1,894,700 workers, but by 2024, the number had fallen to 1,295,300. I've done quite well with the figures there. It's never my strong, not my strong point, Dennis. And I crunched the math. Wow. That's just about in the realms of my capabilities. And that's a drop of 599,400 staff members. So that's an average atrophy, I love that word, of over 46,000 staff members per year.
Well, Helen, these figures were released, of course, as the GMB and other unions begin talks with the LGA over the council workers' pay claim for 2025-26. The LGA said working in local government has never been more valued or important, given the hundreds of essential services provided every day by councils to keep communities running. An LGA spokesman said, significant staff shortages in local government risk having a serious impact on councils' capacity to deliver services and help government meet their key pledges. And government investment in local government and its workforce is key to ensuring services are protected and also to deliver on the government's own policy agenda.
Yeah. I mean, we know, don't we, local government recruitment struggles. And I think this stems from several challenges. It's complex. It's not straightforward, obviously. But I mean, obviously, you've got, I was about to say, obviously, and it's not obvious, pay compared to the private sector for skilled jobs has to be a factor. Then you've got complex and lengthy recruitment practices with delayed interview times compared to perhaps, say, the private sector. You've got workload and stress. And I also think there's something around perception and branding which plays a part. I mean, first of all, don't we? We hear bad news all the time about the sector. But I also think it struggles to get its diverse career opportunities out there. Although I do know the government has recently ploughed funding into public sector advertisements for a career in local government. I don't know if you've seen any posters up on billboards, Dennis, anywhere, but
Indeed, I have seen the odd thing, yes.
Yeah. And I think, LLG, we are working hard to try and address recruitment and succession issues. And we're forging very proactive links with a number of authorities and, of course, universities. And our work experience week is now in its 4th year, but that really is a drop in the ocean. And obviously focuses just on the legal sector. But the LGA too are being proactive in a number of departmental areas to attract employees into what I consider to be the highly rewarding role of local government employment. And on that note, that's it for another edition of the podcast. You can read more on the items discussed today and many more besides by going to bulletin number 16, available on the LLG website now. So it's goodbye from me.
And from me too. Goodbye now.